Mr. Francisco, can I ask you, following up on Justice Sotomayor, if we just put aside the reasonable precautions versus intentional tests, let's say that we decide to stick with the board's formulation of reasonable precautions. Can you talk a little bit more about this jurisdictional hiatus principle? Because it seems to me that if conduct is arguably protected, that might be because of a dispute about the law, like we're not sure what the statute means, or it might mean because there's a dispute about the facts.
Right.
And so the government points out that, the standard for a motion to dismiss assumes the facts are true, that the board here is engaged in some factual discovery and showed that maybe that's not as clear-cut as it might reflect on the pleading. So can you address that?
I think it addresses whether there's a dispute about the law. And I think it makes sense when you understand Garmin in the context of how preemption works in virtually every other context. State courts adjudicate tort claims all the time, including in areas of intense federal regulation. But they're still bound by federal law. So a state court will adjudicate the claim, and on the motion to dismiss, it'll look at the facts alleged, and it will say, is there a conflict with federal law? Or in the case of Garmin, is there an arguable conflict with federal law?
Doesn't Garmin do something a little bit different? Didn't Garmin route both these potentially factual disputes and legal disputes? Garmin is a very different kind of, well, not very different, but it's certainly a different and more expansive kind of preemption.
It is a different kind of preemption, but not in the way I think Your Honor is suggesting. What Garmin did was it said that in addition to having to grant a preemption defense in the face of an actual conflict, that's the rule virtually everywhere else. You also have to grant a preemption defense in the face of an arguable conflict. But I don't understand Garmin to be a wholesale overturning of how preemption works in every other context. And in every other context, states courts still get to adjudicate the claim, and they grant a preemption defense once it becomes clear that on the facts alleged or the facts proved, there's either an arguable conflict or an actual conflict.
So
with
it's
the
summary
NLRA.
Judgment then, there's summary judgment, then that would be the time.
Absolutely.
Say, okay.
If at summary judgment it became clear that on the facts, under the applicable summary judgment standard, there was an arguable conflict, you grant the preemption defense at that time.